I will say, just a minute ago, Mr. O'Leary, you were being asked by Senator Whitehouse about investigating members of Congress, and it is certainly true that DOJ has a long tradition if there's evidence of particular misconduct. For example, our former colleague, Senator Menendez, is currently incarcerated in prison for corruption, and if you've got evidence of criminal conduct of one individual, the Department of Justice has an obligation to investigate that. Okay. Would you agree that's qualitatively different than a fishing expedition targeting 20% of the Republicans in the Senate? Would you agree that's qualitatively different?
I'm not familiar with the details of either investigation, so I wouldn't want to speculate.
Well, let me ask you this. Would you be troubled if tomorrow the Trump Department of Justice issued a subpoena for the phone records of every Democrat that sits on the Judiciary Committee?
Not if it was based on factual evidence, specific and articulable facts.
Well, let me be clear. I'd be damn troubled. And that would be an abuse of power. And I'm going to predict not a single Democrat's going to say even a word about the abuse of power on their side. And that double standard is troubling. Senator Lee.
Thank you very much, Senator Cruz, for convening this hearing. It's an important topic. About a half century ago, President Nixon resigned. He did so under pressure on the basis of public outrage that stemmed from a break-in at DNC headquarters. It's an act of lawfare, you might say, or maybe better said, political espionage. Today, the media and my Democrat colleagues have fallen conspicuously silent when confronted with a scandal that in some ways is of much larger proportions, because it involves the official law enforcement apparatus of the U.S. government in a much more direct way than that one did. President Biden's systematic weaponization of the Department of Justice and federal law enforcement against his political opponents is a development of staggering proportions. And by development, I mean scandal. Just like the Watergate break-in, Arctic frost was ultimately an attempt to sway the results of a presidential election. But this comparison may even be unfair to President Nixon, who never attempted to quash dissent by putting the opposition candidate in prison for trumped-up charges. Now, thankfully, the Biden administration failed in that misguided effort. President Trump was elected by the people to become the 47th president of the United States. But we have to ensure that this kind of lawfare can't occur again. Mr. Chamberlain, I'd like to start with you. Your testimony focuses, among other things, on an FBI recording of a 2023 phone call between Susie Wiles, who was at the time managing President Trump's presidential campaign, and her lawyer. Now, according to the FBI, the lawyer was aware of the recording, but isn't it true that the lawyer denied that he had ever consented to that arrangement?
That's true. That was widely reported.
And if, in fact, the lawyer did not consent, your testimony today is that this would have been and was an illegal wiretap by the FBI in the absence of her lawyer's consent with the FBI.
That's correct.
And the FBI designated this as a prohibited file to prevent anyone from finding out about it.
That seems to be correct, yes.
Okay, so they did something they weren't supposed to do, then they designated it as a prohibited file to cover it up. Now, in general, should the president be able to direct the FBI to spy on the campaign of his political opponent?
Absolutely not.
And isn't listening to a private conversation between a presidential campaign manager and her lawyer in many ways much more serious as an abuse of government power than an attempted wiretap of the DNC headquarters in Watergate?
Correct, because there's two interests being invaded. First is just the wiretap generally, but then it's doubly invasive because it's supposed to be a privileged conversation. A
privileged conversation, which regardless of who's involved in it, is supposed to be privileged. And that takes on additional flavor and additional degrees of seriousness when that person happens to be a client represented by a lawyer who happens to be managing the presidential campaign of the then incumbent president's lead and exclusive challenger, effectively. Ms. Cleveland, you referenced the FBI's use of protected access tag for Arctic frost subpoenas. What is this functionality, and why does it raise due process concerns in your mind?
So prohibited access is a functionality which makes the records invisible. So when there's an investigation going on, the FBI agents are doing searches maybe by keywords of names, it will come back and say there are no results. They will believe there are no results. We already have evidence that this has been used in the investigation of Trump. We also have evidence that has been used in other investigations that were high profile. From the due process concern, a lawyer is entitled to have evidence that is exculpatory to their clients. If there is exculpatory evidence or even evidence that calls into credibility, that the credibility of one of the witnesses, that has to be turned over. It can't possibly.
For Brady and Giglio purposes, yeah.
Exactly,
Right.
Brady Giglio. It can't be turned over if they don't know about it. That's a huge problem from the due process perspective.
Right, so you're forestalling up front what would be part of the defendant's due process in the event of eventual criminal proceedings. Now, really quickly before my time expires, tell me whether to what extent Judge Boasberg knew or would have had reason to know what the NDOs were actually covering.
So without seeing the application, it's impossible to say he should have known. But this morning when Senator Grassley released his documents, it indicated that Smith's team was speaking with the prior chief judge of the DC District Court about subpoenas and executive privilege. So that raised the concern of, was this conversation going on with Judge Boasberg as well? If not, did Smith's team actually decide not to have the same kind of conversations because they were concerned that Judge Boasberg wouldn't go along with it? So we don't know what Judge Boasberg knew, but we do know he didn't demand Smith come in and explain himself, as he has done time and time again with the Trump administration in trying to hold someone in contempt there.
Okay, so this would be outside the norm, not only for this type of action, but out of norm even for what Judge Boasberg has done in other cases.
In the contempt, in calling them in for contempt, absolutely.
Thank you.
My turn.
Senator Durbin.
Thank you, Senator Lee. Ms. Cleveland, you've given a pretty lengthy bill of particulars in reference to the special prosecutor, Jack Smith. I tried to keep up with your statement. You've accused him of being a hyper-aggressive prosecutor, partisan, deputies who are politically partisan, running some sort of partisan protection racket, unconstitutionally appointed, a litany of constitutional misconduct, guilty of a fishing expedition, and on and on. Would there be value for you to be able to ask Mr. Smith questions about your assertions?
Only after I've seen enough background information to poise good questions, such as Senator Grassley's release this morning revealed for the first time that he had.
No, I'm just asking in general terms, not to get specific.
Well, as a lawyer, I have to give you the specific answers to the question.
Well, I'd like you to do it very briefly because I have a limited period of time. I'm just asking you if you had a chance to ask Jack Smith questions.
Not until I've seen the documents that will inform the questions and be able to confront him. You don't do a deposition until you've done document review.
Well, of course, I think that goes without saying in the practice of law. But let me ask you if you could ask him questions under oath, whether that would be more value than just general questions?
Again, after I've seen the documents.
You don't think being under oath puts any special obligation on a person who is asked a question?
You can be under oath, and if you're not confronted with the evidence, the answer is not going to be as informative.
It sounds like you're afraid to face him.
Not at all.
Well, good. Let me ask you this question. If you could do it in the setting of, say, the Senate Judiciary Committee, and you had a chance to ask those questions under oath, do you think that might be of value?
After I've reviewed all of the relevant documents, including the ones hidden in prohibited access.
How about we make sure that that meeting of the Judiciary Committee is public so America can witness the questions and answers? Would that be of value?
after all of those documents have been released, yes.
Oh, you wouldn't want to testify, you wouldn't want to question him until all the documents have been released?
The relevant documents that are hidden in prohibited access, absolutely need those before you question him.
That may be a luxury which most attorneys and others would not have access to.
Well, they shouldn't have been hidden in the first place.
Well, it isn't a question of hiding as much as legal access.